Okay, let the record reflect that the defendant is present along with counsel for the defendant, Assistant State Attorney, the attorney for JAC. Mr. Baez, you may continue, sir.
The next person on our list, Your Honor, would be our forensic entomologist. This person has been present on the case since December 11th of 2008 and has done significant work. The state also...
Does the state have one?
Yes, not only do they have one, their entomologist is also out of state. And
where does your entomologist hail from?
Nebraska.
And where does the state's expert hail from?
Indiana.
Is that person willing to accept the rates established by JAC?
Yes, sir.
JAC's attorney, any objection? You may want to just kind of stay closer.
Yes, sir. I would like to point out to the court, Your Honor, that the defense is not necessarily entitled to what the state has. The defense is entitled to what would be provided if this was a public defender case or an Office of Regional Counsel case or a private court-appointed attorney case. Simply because the defense has expended great resources in the past on the experts of its choosing does not necessarily require that those experts continue at taxpayer cost. We would object to, again, out-of-state providers based on the travel expenses. We do appreciate the expert will work at JAC rates. However, we are objecting based on travel expenses. Thank you.
Your Honor, if I may just add one fact for the court's consideration. None of the entomological evidence has been examined by the defense's expert to this point.
Your Honor, the state has employed Dr. Neil Haskell as their forensic entomologist. To date...
I'm ready to rule, Mr. Baez.
Sure.
The court has reviewed the landmark case of Ake versus Oklahoma. And the court has reviewed the other cases cited by the defense. Lavender and Walls versus State, which is found at 926 7th 2nd 1153. The court finds that that particular expert is relevant and necessary. The court also finds that the defendant in this case is charged with murder in the first degree. The state has filed a notice that they intend to seek the death penalty in this case. And balancing the interests and considering the Florida Constitution and the United States Constitution, the Due Process Clause, which talks about fundamental fairness, the fact that this expert has already been retained, that we have an adversarial system of justice, that this case is more than 2 years old, and to require the defense now to go out and secure a new expert simply because the expert is not in the state of Florida would cause this case to be delayed. And since, because of our system of justice, is memory dependent, not necessarily with the experts, but the other fact witnesses in this case who are lay people, and balancing all of those interests, the court will permit this expert will be bound by the rules of JAC and the applicable rules of evidence in this case. Thank you. Who's your next one, Mr. Baez?
Yes, sir. Our next is the forensic anthropologist. I can tell you
The
that.
attorney for JC, if you want to drag your chair and put it up closer to the front, then that way you won't have to just stand there and,
I can represent to the court that
who's the next one? I missed that, Mr. Baez.
I'm sorry, Judge. A forensic anthropologist.
Okay.
I can represent to the court that the remains of Kaylee Murray Anthony had a full anthropological exam. Since then, her remains were cremated by Miss Anthony's parents, so it would be absolutely impossible to duplicate that exam. The state also, as mentioned, has an anthropologist, and our expert is willing to accept JEC rates.
Mr. Ashton or Ms. Drain, any objections on the grounds of relevancy and necessary?
No, Your Honor, he's correct. We actually have more than one forensic anthropologist in the case, so.
JAC's position?
No, I would like to point out normally that, Your Honor, under JAC policies and procedures to which Mr. Baez is contractually obligated, we do require a written motion and at least 5 days' notice prior to any hearing on a request for experts. In view of the necessities of this case, of course, we're waiving that at this time, Your Honor. As to the forensic anthropologist who has agreed to work at ISC rates, we have no objection.
Okay. Granted. Next one.
The next witness would be a forensic botanist. Our forensic botanist was hired December 31st of 2008, and she is also willing to accept the JAC rates. The state has a forensic botanist.
Where's your botanist from?
Colorado. The only other well-known botanist that actually resides in the state of Florida, which has been contracted by the state, will testify to a critical issue in the case, which is the possible timing of the placement of Kaylee Murray Anthony's remains at the recovery site off of Suburban Drive.
Mr. Ashton?
Yes, Your Honor, we do have a forensic botanist in the case. I'm not aware of any other forensic botanist in the state of Florida. Also, the evidence has not been examined as of yet by the defense expert. But it is appropriate.
I can correct my colleague on that. Our forensic botanist has visited the location where the remains were recovered 2 times, and in addition to that has observed the photographs that were taken by crime scene experts, which was basically the same way, according to the state's expert witness, the same way he analyzed the site, albeit certainly a lot closer in time because he had access, whereas we were denied access.
JAC?
We'll defer to the court on this, Your Honor.
The court found, based upon what has been presented, that this particular expert is relevant and necessary. Therefore, it will grant the request. The botanist is governed by the JAC contracts and applicable rates associated with that. Next.
Next is forensic pathologists, Your Honor. The defense has retained 2. However, only one will be testifying in the case. And again, there was a second autopsy completed, which of course cannot be redone. So travel would only apply to one of them.
Well, are you asking me to pay for one, or are you asking me to pay for 2?
We're asking for 2.
Now you're going to have to. If you're going to have only one testifying, why do I need to pay for 2?
For consultation?
No, sir. 1. the state will only pick up the tab on one.
My mother always says, if you never ask, you never receive, so.
Yeah, and you have your answer. JAC?
The state, Mr. Bias has not addressed rates for the pathologist.
I believe I did in my motion, Judge. The pathologist is willing to accept the JAC rates.
Yeah. That's all they're going to get paid, the JAC rates, so
Very good.
they can bill whatever they want to bill. What they get paid is a horse of a different color. It will be JAC rates. Mr. Ashton?
Just by counsel.
Okay.
And for the record, all of our experts are willing to accept the JAC rates, so.
Well, whatever, they're only going to be paid JAC rates.
What I was mentioning to counsel was I know that I believe that the defense has hired an in-state forensic pathologist and perhaps an out-of-state one. I wasn't sure it was clear which one it was they said they want, the in-state or the out-of-state.
Good question. Which one?
No, it's the out-of-state. It's the out-of-state.
Okay.
forensic.
Why are you choosing the out-of-state one versus the in-state one?
I never said that we retained an in-state one. We've consulted with an in-state one, but the one that conducted the autopsy on December 24th of 2008 was an out-of-state forensic pathologist. And that's been made public, Dr. Werner Spitz.
Okay. So there was a second autopsy done,
Correct.
and that was done by your expert,
Yes.
and subsequent to that, the body was cremated.
Correct.
Okay. Okay. Request with Mr.
Your Honor, if I may, it's not clear that whether or not the in-state expert cannot competently review the autopsy results and render an expert opinion based on those.
I'll see if I can be clear. We have not retained an in-state expert. I've consulted with one, but that expert has not been retained and is not a part of the defense team or a part of this case.
While under the case law, under the business records exception, someone can testify as to an autopsy that they did not do, but that's not the most preferable way to do it. It is usually done in instances of last resort when someone is dead or unavailable, and then they look at the records and then they testify. But again, this is an unusual case, and I will grant the defense's request. Again, they will be subject to the rates that are set out by JAC. Next.
The next would be a digital forensics expert, basically a computer expert. We anticipate digital forensics to play a role in the state's case. It is absolutely necessary that we have someone that can testify as to other items and other interpretations of the state's case.
Mr. Ashton or Ms. Drain, is there going to be someone testifying as to digital images on a computer?
There is. The sheriff's office has people on staff who reviewed that evidence, and this is somebody who has already been listed by the defense who took a mirror image of the hard drive, as I mentioned earlier, unless he's speaking of somebody else, and that person is out of state as well.
Does this person hail from the state of Florida, or are they out of state?
Out of state, Your Honor.
Where from out of state?
North Carolina.
And just out of curiosity, why you didn't get anybody in state?
Well, some of this expert has worked with other attorneys that are on the defense team, as well as the rates that he was giving us were an offer we couldn't refuse.
Okay. And I take it This person has probably done their examinations?
Yes. He's had a mirror copy of the hard drives in question.
And approximately how many hours has he put in that you've already paid for?
I think that all that would be required is there are some other files.
No. How many hours has he already put in that you've already paid him for? What I'm trying to determine is this evidence is here. I would have to go back, if I granted you an expert, have someone go back and redo all the work he's done. I'm trying to ascertain, is there a savings by retaining this person? If he's done 50+% of the work already, then there's a savings. If he's only done 5%, then there's not a savings.
I know there's well over 50%. The only thing left to do is some minor consultation and deposition and testimony. My understanding of the depositions, a majority of them are being done via Skype, so there's no travel involved for that, unless the state decided to. Other than that, that's all that's left. Now,
with some of these depositions, you do know that we have the capability in the Orange County Courthouse for video conferencing. And if I can make that available for basically free of charge, except for the other end, where you can see them, and you may have to make sure that you have 2 sets of documents if you're going to question them on documents, and have those marked and FedEx up there so they can be referenced. JAC?
That was going to be my point, Your Honor, that travel for many consultations or depositions may not be necessary because of electronic alternatives, and I'd just like to point that out to the court as well. As regarding the expert, we'll defer to the court.
Mr. Baez, if you need to consult with these folks, video conferencing is a good way to do it.
We've done that with numerous depositions already with the state, for both state witnesses and defense witnesses. So,
request would be granted, bound by JAC rules. Next
would be a DNA expert, Your Honor. State has utilized the DNA 1 and 2 sections of the FBI, and there's a substantial amount of evidence that has been utilized in their laboratories, and we believe it would be essential to the case.
State, you're utilizing DNA evidence?
We have both mitochondrial and nuclear, and I believe that the witness has already been listed, Dr. Kobylinski. Is that the counsel is referring to?
No.
Okay, that was who had been announced as the DNA expert in the case, but Dr. Kobylinski. Is he?
He has not been. I'm sorry.
I've told you as much as you asked me. So,
Mr. Baez, would you like to clarify who your expert is?
I'd rather not, Your Honor, unless it's...
Well, if we're going to pay for it and he's going to testify, I think you need to tell me. If he's not going to testify, then that's fine, because we don't need to pay for it.
Right now, Your Honor, we've been using the bioinformatics laboratory, not a laboratory, consultants. Specifically, the person, there's a group of people right now who are reviewing the evidence. However, we haven't made a determination as to which one will testify. But I can tell you that there will be someone testifying in relation to the DNA evidence in this case. A good reason for that issue is we just, I want to say 2 weeks ago, finished deposing the FBI DNA analyst, and we are still getting certain bench notes and background data. We've got a majority of it now, but it's, I want to say, the last day or two have been shipped to our DNA people.
Put it this way, and I'll let Mr. Ashton speak in a moment. He looked like he wants to say something. There will be, go ahead, Mr. Ashton.
No, I was just going to say the recent documents had nothing to do with DNA. They were other forensic specialists, not DNA. Just correcting that one thing.
You only get one.
Understood.
So you can have as many look at it, consult, but we're only paying for one. Now, I know JAC is interested in why this isn't done locally in the state of Florida. Correct?
That is correct, Your Honor. As a matter of fact, we are aware of several DNA experts that are regularly used in capital cases throughout Florida. I'd be happy to provide their names to counsel. Apparently, this is an out-of-state DNA expert.
Yes, they are, and I can tell you the extent of the work that they've done so far. There are numerous items that were tested for DNA, and I can certainly say that well over 60% of the work has already been done, including the review of the electropherograms, the different runs of DNA from both nuclear and mitochondrial DNA. We've requested and received, from my understanding, a great majority of the bench notes. All of this work has been done. To go back and have someone locally do it would certainly not be cost effective.
JAC?
Of course, it's counsel's burden to make that showing. I personally don't have enough knowledge in forensic DNA evidence to add anything to that at this point, Your Honor. We'll defer to the court on this matter.
The unique thing about DNA examinations is sometimes some of the samples are consumed by DNA testing, and sometimes there are not enough samples to go around. But I'm going to grant the request. We are subject to the JAC regulations, and only one. You're free to have as many people donate services as you want to, but only one. Next.
Next would be, now I categorize this person as trace evidence. And
when you say trace evidence, be a little bit more specific. Are you talking about hair, fibers?
hair fibers, textile fibers, soil samples, all of these items were submitted. All of these tests were run by the state. In our case, we have not assigned that specific work to Dr. Henry Lee. However, if he should do it, that would fall under that category, under Dr. Henry Lee. However, in the event that Dr. Lee is not able to do that, we will hire an in-state expert for that.
Well, let me ask you this. Is Dr. Lee going to do it?
I'm sorry?
I've already said that you could have Dr. Lee. Is he going to do the trace evidence?
That's something that we haven't gotten to yet as far as...
Well, until we get to it, I'm not going to... if Dr. Lee can do it, we're paying for his travel, I'm not going to pay for somebody else.
Understood.
So we need to find out if Dr. Lee is going to do it. If he's not going to do it, I'm going to need to know why.
Understood.
I think he's eminently qualified to do it, so next, that request there will be denied without prejudice in view of the fact that Dr. Lee can do the same work, and if you have a problem, come back.